Yeah, you're always late. What's up? What's up? What's up, Adrian? What's up, YouTubers, Facebookies, TikTokies up there? IG should be logging in too. We are live
I'm
on
through.
all platforms. Pretty soon we're gonna do some Snapchat as well. I don't know if you can go live on now on there with them, but we live on all platforms. Adrian, how are you?
I'm good. I'm good. Motivated, feeling empowered. It's Juneteenth. Want to represent for the people. For my
Okay,
folks.
okay.
So what I'm saying. Just here, engaged, and ready to go.
Listen, okay, so we got some news going on, Adrian, that I have to get your opinion on. I know we have a lot of people on TikTok that's been tapping into this issue, on YouTube that's been tapping into this issue as well. Okay, so we had did a show before on, we covered Young Thug's trial, a little bit of it. That trial is off the chain, really it is. There's a lot going on, so that's why I didn't go on there every day of looking at this, because you would just go crazy.
Yeah.
But I did tune in. When I did tune in, I caught some good stuff on it.
Yeah.
So this is the first time that I've ever seen this, and I sent you the content on it. Have you ever seen a judge literally have an attorney arrested in trial?
Well, it's like not. I wouldn't say it's uncommon. It's just like rare that a judge would do that, but that's part. That can be part of the process, the proceedings, depending on on the behavior of the attorneys.
Right. So, okay, so let's just go into this. So, let me set the stage and then I'm going to play a little of the recording on it. I think this first one is like 3 minutes.
Yeah.
Um so basically what happened is that the judge, so there's a witness in this case by the name of Woody. Um Last week Woody took the fifth. It was already an issue with Woody taking the fifth for the defense, because the defense claimed then last week that the prosecution already knew that Woody was going to take the fifth, and they still allowed him to go on the stand in front of the jury.
Yeah.
Say he's going to take the fifth. Now, I'm not an attorney. I've watched some cases and everything and I analyzed the stuff, but I didn't understand why the defense had a problem with the jury hearing Woody say he was going to take the fifth. Now, Woody, I guess, would be considered a part of their gang or whatever. So I guess they were saying that makes their clients, the defendants in this case, look bad by him saying that he was going to take the fifth. Anyway, fast forward. So when Woody took the fifth, the judge told him, "Well, we're going to leave you in jail over the weekend to see if you change your mind." Basically, he ordered the attorneys to be back in court Monday morning at 8:30. They're going to start at 9.
Yeah.
Most of the defense attorneys said they was there between 8:30 and 8:40, right? Court
Yeah.
didn't start until 11 that
Yeah.
morning.
About 11. Yeah, I saw that.
So no one knew what was going on. No one came out and told them anything. Some kind of way, Brian Steele, Young Thug's attorney, got word, saw emails or something, that there was a meeting going on with the district attorney, the judge, and a sworn in witness. They're calling this an ex parte meeting, um, which is, legal. But I went over some Georgia laws with this
Yeah.
ex parte thing. So the defense people, they really have something on this. So let me go ahead, and we're going to go ahead and get into this content. Let's go ahead. I want to give a shout out to all of my TikTok followers and people that came in. Hootie Hoo, what's up? Welcome to the Hootie Hoo Finest Talk Show. Let's get into this content, Adrian. Hold on one second. Let me see. Because I want to show how this whole this thing got started with Brian Steele going to jail. I mean, getting in contempt of court to go to jail. Hold on, that's not it. It's this one. This one. Okay, so let's see here. Let me see how this goes. Always. Okay. Let's go bigger. And this is only 3 minutes, so let's play. Can you see it, Adrian?
Yes, I can see it.
Forward. Right. What I was told was that Mr. Copeland said,
and you haven't answered my question yet.
I'm not. How did you answer that question?
You're not.
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to.
No. I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based on information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have this. I have problems right now.
Okay, I know. Look, I don't want to know about your problems. Okay, at this point in time, all I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversations with a party. I mean,
a witness who was sworn in Friday. The court's telling, this is what I was told. If this is not true, not true. This court handed Mr. Copeland.
Tell me how you got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it
or
proprietary?
Information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court,
okay.
Or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come?
Okay, so let's start right there, Adrian. What is all of this? Salute Bunny Elizabeth is in our chat, Adrian, visiting us, and we got a whole host of people. Hey, Cuzzo on TikTok, I see you. All right, so Adrian, what did you get out of that, man? Like, for that little part right there, it seemed to me that the judge really didn't want him to say what was said, what the information was that he had. Did you get that?
Yeah, I got that because, whenever you're dealing with the legal system, right? The legal system is, it's unemotional, it's unfeeling, it's very linear, and it's like based on precedents, right? It's based on case law, case records. And like you said, I'm not an attorney. My legal teachings come from my 27 years in prison and fight my own legal battles. I fought my own appeal for several years. So when you first mentioned ex parte to me, before a couple of days ago, I remember having an ex parte hearing. With the judge, outside of the presence of the prosecution. Mm-hmm. So, that's what it is. The ex parte is like one party having access to the judge, whether that be the prosecution, the defense attorney, or even a juror. You know, a juror can ask for an ex parte hearing with the judge. You know,
Now,
just
let me
to,
ask you this before I
yeah,
lose this about your ex parte hearing.
okay.
Were you in trial? Was you in trial at that time?
Well, I had my first trial. My first trial actually in a hung jury, right?
Uh-huh.
You know, so I remember having a second trial, and you know, my first trial I had a paid attorney. You know, I paid this attorney like close to $30,000. He represented me pretty good. I got a hung jury, even though there was a lot of evidence, some unscrupulous against me. So no, this happened between trials before I went to my second trial, and I was trying to get rid of the public defender. You know, we used to call them public pretenders. You know, back in the days. You know,
No
but
offense, public defenders, we love y'all too, but some of y'all,
yeah, you know, they're very good public
some of them have
defenders, and you know,
good
so
ones.
you know, I won't dispel, just to dispel that myth that all of them are bad, but you know, a lot of them just have a heavy caseload. But anyway, so that's why I filed the ex parte motion, a hearing to file what they call a Marsden hearing, so that I can speak to the judge outside the presence of the prosecution.
Okay, so that I get that. I understand that part. But there's something different when you're in trial and you're a sworn witness on the stand. And I'm gonna get into that in a little bit. I pulled up Georgia law, exactly what this attorney was trying to tell the judge. But for some reason, this judge, you just pay attention to this judge, Adrian. Pay attention to him. Hold on one second. We're about to get back into this.
Upon this information, who told you?
What I want to know is why wasn't I there? Why,
Sir, I'm going to hold you in contempt if you don't tell me who that. Tell me who this
I
information
don't
was
want to
come
be
from.
held in contempt.
Well,
I'm not
then-
answering that question. That's attorney-client privilege information. I am not answering.
Attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I am
I
telling
tell you
you.
what, I'm going to give you 5 minutes. If you don't tell me,
You don't
who
have to.
If you don't tell me who it is, I'm going to put you.
Well, let me-
I'm going to put you in contempt
I
because
understand.
that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you?
telling
How did you get that information
I don't
supposedly
answer
from
that
my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to
You
continue.
got 5 minutes.
This is what I was told. Mr. Copeland,
recess.
Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No.
He tried to take his notes to bailiff. Okay, so let's stop that right there. Hold on 1 second. That did stop. Okay. Adrian, okay.
Yeah.
So let's get into this about this judge, because you look at these things totally different from me because I'm emotional.
Yeah.
You know a lot about the way that the law goes. Salute to Active Chucks is in the house. Deuce M's came through to support your girl and Adrian. What's up? We getting into this content. All right, so I look at things. I'm learning to look at things from the law perspective, but I look at a lot of things from emotional perspective too. This judge just seems very emotional about this. Adrian, did you get that? Now, before you answer that, I want to know, do you feel that he's emotional on the fact that the attorney found out what was said in his chambers? Or is he emotional that the attorney found out something that was said that he didn't want him to know?
Well, it would be the first, rather than the latter. The judge, one thing I saw with the judge, yeah, I would be upset too if, this is information that, that's happening in, say my chambers or in my, like he said, his inner sanctum, to some extent, right? And how did this information get out there? Was it my court reporter? Was it, the bailiff or someone else that was involved? So I want to know what's going on. So, hey, man, this person is not loyal to the court. not loyal to me, if I'm putting myself in that judge's position, you know what I'm saying? And that's just being able to, assess, whatever feelings, emotions, being empathetic, right? So yeah, I would have been upset too. So I understand that, not necessarily that he did anything wrong. And, one thing that still he can continue to try to introduce information that there was some impropriety going on during that hearing in the judge's chamber.
Right.
So he's trying to introduce that, but the judge don't even have to address that at this point. Only thing that's at this point, because how linear the law is, we're just going to talk about how did you get this information? Once we find that out, then we move on. That's just how the law works. Then we move on to the next step.
But here's the thing with that, Adrian. And so the judge wants to find out, but what Brian Steele is saying, okay, all of that is going to come out in a hearing. We need a hearing. The judge is like, we're not having a hearing. We're going to let the appellate court take that up. We're not having a hearing. And so that's what I didn't understand. If you really want to find out who said what and how they said it, we got Simply in the building. What's up, Simply? Smoked Out TV came through to support Hootie Who's Finest Talk Show, and Tonda. What's up, Tonda? But but Adrian, if the judge really wants to find out who did what, it has to come out in the hearing, right? So that.
So you're saying if the judge wants to find out what happened, are you referring to the defense attorney wants to find out what happened in the chamber?
Both, right?
Yeah.
So it is Brian Steele's right to bring up this motion, right? If he feels that something has been done, the judge or the court has done something that's not right, he has to make that motion and put it in record, right? On his client's behalf.
Well, by him, introducing this information, it has to have some type of factual grounding, right? So him introducing this information, where did you get this information from? And he's not willing to reveal where that information came from. So without that evidence, it's just an accusation at this point,
Right.
So, and that's what the judge, that wouldn't make anyone upset if you making some type of allegation against me that's founded on some hearsay, or what you believe that happened, or what you believe that occurred, because at this point, that's all it is,
Right.
And like I say, that's just how the legal system work. You can have some constitutional issues, and if you're time barred and you ran out of time and you didn't file your case on time, they're not even going to address the constitutional issue. You can try to later on compel them, and state that, look, a constitutional violation will occur unless this information come in. But first, they're going to address your time bar. We don't need the prosecution. We don't even have to talk about or litigate or argue your issues. We're going to argue just that your time bar. Once we get through with that argument, and if you're able to satisfy the court and get past that, because the court may rule, the prosecution's right, your time bar. So you might have an actual constitutional issue that you want to raise that's legit and has merit, but you still have to get over that time bar. And that's the same thing that's going on now. The judge is saying, how did you get this information? Then we'll address whatever motion that you have with concerns to the impropriety that you believe that's going on. Let me find out where is this information, because right now, like I said, it's just an allegation,
Allegation. Okay, so we got Messy Marv in the chat. He says, salute, Tree Tips, and Adrian. What's up? Messy Marv came through. Show us girls some support. Caught they ass, Active Chuck said. They case ain't together. I don't believe that their case is together too. But I think that in this case with them arresting him, what I've researched and learned is that the judge had a right to do it. I mean, he had the right to. So, and I knew that's what you was going to give me, Adrian. But I do have something in my hip pocket for you as it pertains to the ex parte law of communications in Georgia. What this judge was supposed to do. Now, the crazy part about this is these judges be having too much power and too much control. He really don't even have to address this until if they get caught up. I think this is the appellate he's talking about. I'm just going to let the appellate court address that. So he's basically saying if they get found guilty, then you can raise this up as an issue in the appellate court. Is that what he's meaning when he say I'm not addressing that? We're not having a hearing. I'm going to let the appellate court address that.
Yeah. So yeah, that part is true, right? You know, but what a lot of people don't realize, you can appeal a decision of a judge before you're convicted. And a lot of attorneys, you know, they don't do that because it's like prolong the proceedings. It's like going over this judge's head, and you don't want to have this, you know, animus between, you know, the defense and say the court, the judge. Mm-hmm. But so whatever ruling that the judge ruled right now, they can take that ruling before you know, Young Thug is convicted or any of them are convicted, and take it to another court, a higher court of Georgia. And appeal that judge's decision, you know. Okay. But you know, usually in that situation, the appellate courts will like send it back down to the court and say and tell them like, look, wait till the proceedings are over. You know what I'm saying? So you know, so you can appeal in the middle of a trial before someone is convicted, but usually they wait till after trial, the outcome of the trial, then raise it on appeal. So that is what the judge is talking about.
So if you raise it on the appeal during trial, if the judge is in error, right?
Yeah.
You can raise it on an appeal during trial, basically.
Yes,
you can. Okay, so let me bring up this.
To a court higher than the court, say the municipal court or the county court, you know. Of you know, Atlanta or Fulton.
Right. Yeah. Okay, so let's bring up what Attorney Steele was giving the judge as it pertains to ex parte communications in the state of Georgia. And as you know, these things is different per state, right? A lot of this stuff.
That's true.
So as it pertains to Georgia, let's look at, hold on one second. Let me present so we can look at it together. Where are you? There it is. Okay, so let's look at this together, Adrian. Okay, it says Rule 616-1-2-.10. Ex parte communications. This is case text in Georgia for Georgia comp R and regulations, basically. It says once a case is before the court, no person shall communicate with the assigned judge relating to the merits of the case without the knowledge and consent of all other parties to the matter, provided that the judge may communicate with other judges related to the merits of the case at any time, or where circumstances require ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with substantive matters or issues on the merits, provided that 1, the judge reasonably believes that no party will gain procedural or tactical advantage as a result of the ex parte communications, and the judge makes provisions to promptly notify all other parties of the substance of the ex parte communication and allows them an opportunity to respond. What you think about that, Adrian?
Well, like they said, so I don't think Steele gave him, you know, that fourth paragraph. So still didn't even give him a chance to provide him with any information that happened in the ex parte hearing, right? You know, and like they said, you know, if it's not substantive or meritorious to the case at hand, then, you know, the ex parte should not take place, right? But one thing when you go into the legalities and the wording of these things, like, so they had a provision for emergencies. So we don't know what's going on, why the prosecution requested an ex parte hearing with this witness. Maybe this witness told the prosecution, the DA, look, my life is in danger. You know, I feel like, you know, I need to be transferred to another institution, whatever it may be. And he requested, look, let me speak to the judge, you know, and, you know, and that could have been, it could have been as innocuous as that, right? And still didn't get a judge an opportunity to, like, look, this is what happened in the chambers with this ex parte hearing. So, you know, there's so many outs that the legal system have at their disposal. Like you said, the judge, they have so much power, and they give the prosecution, the district attorney, so much leverage, where the defense, you know, you have to rely on, you know, presidents, you know, the law, the case, you know, case records and shit like that, right? You know, where the judge and prosecution, they have a lot of leeway, and they have, you know, this infrastructure that's, you know, the average defendant cannot, you know, contend with, you know?
Right. Okay, so what happened is, okay, before we go on, let's give a shout out to Nene. Mama is in the house. She said hello. We got C-Red. Do salute to the room. What's up, Tree? What's up, baby? We got Dice TV in the house. My big bro always coming through to support. Don Moore and Keyway Conversations is always connected in so many ways. Yes, we are. Yes, we are, because we all grew up together. We all lived together. We all went to school together. So yeah, it's time that we get up in age and start connecting on some positive stuff, making some money together, right, Adrian?
Yeah, I like that. I like making money
that too. All right, so Adrian, I got some more content about this because it got very interesting. After he had Brian Steele arrested. He put him in contempt, right? I didn't know that there was different kinds of contempt. There's a civil contempt, and then there's a criminal contempt. I think the judge actually got the whole thing mixed up as well with this contempt thing. So Brian Steele had about 25 defense attorneys to come to court that day. All these attorneys showed up in court to defend him. But he chose the lady that was trying to bring down Fani Willis for Trump. And she came in and cut the rug up on the judge. We gonna play a little bit of it, and then because she got into some factual things. I think she made a good point, because the judge basically, I think he charged Brian Attorney Steele with criminal contempt, but what he was saying was it was really civil contempt. He wanted him to pay the penalty of criminal contempt and receive no bail, I guess. But what he was saying he did was really civil contempt. So let's get into this content. We're going to share some of it. Nene said, hi, hey, Adrian.
What's up, Nene?
I got Nene talking about, hey, Adrian.
Mm-hmm. That's mama right there.
That is mama.
Mm-hmm.
Okay, mama, so let's you already know. Yeah, already know. Hold on. Let me see if I can. Okay, here we go.
Is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
No, with criminal contempt, I told him what the contempt was, and that was he refused to tell, order the court.
Hold on. You can see this thing going. And I was lucky because my internet had went down.
Counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt.
Hold on.
So I've asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said. I just want to know who it was, because he's got too much detail of this particular alleged conversation for the court to be concerned about it. So,
And Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to witness list. We're entitled to present our own witness list.
oh
and
no,
notice of that.
criminal contempt is different. It is on the
My internet is tripping. So in this, let me take it off. Let me stop presenting.
Yeah, one thing
So-
about it, when it comes to, and like you say, Georgia law, state law, from state to state is just a little bit different, right? But it's universal that criminal and civil law, they go hand in hand. It's basically almost the same thing. There may be small differences when it comes to it, but it's all one and the same, essentially.
Yeah, so what she was trying to explain to him, and she broke it down, and she brought in another attorney to break it down to him as well, because he actually got it mixed up, and that was my concern with him with this whole thing. I look at things in a big picture way, because if you got it mixed up with the difference between civil contempt and criminal contempt, that just further lets me know that. And if you guys go back and look at some of this, you'll see he took a long time when they really broke it down to him what you're saying. He took a minute to look at the screen to see what exactly. Then he took a 5-minute break that went into 2 hours to see exactly what was he's saying. But for me, for you to, as a judge, to get those two things mixed up, you're charging them with one thing and you're really saying another thing. Did you really go over the Georgia law as it pertains to ex parte? Because it clearly states that those defense attorneys should have been notified and should have been agreed to that ex parte, because this person was a witness.
Well, I don't know. I don't agree with that. That they have to agree with the ex parte. That's why it is ex parte. They don't have to agree. It's something that's.
But it's a sworn witness. It's a sworn witness.
If that witness asks for ex parte hearing, that witness has the right to it. Outside of the presence of the district attorney or the defense attorney, they want to speak to the jury. So no, the judge was within his rights to, give the ex parte motion to, we don't know who asked for it. Was it the prosecution on behalf of the witness? Was it the witness himself or herself, or was it the witness attorney? Now, once the hearing is over, now the judge has an obligation to release whatever information that was conveyed in that hearing to the defense attorney.
And he has it.
So it's like I'm playing devil's advocate here, that but I'm just like putting the facts out there, because it's like, in this country, ignorance of the law is no excuse. If you don't know, okay, I didn't know I was committing a crime. No, they don't want to hear that. Your ass going to jail, right?
Right.
And so these are things that we need to know. I didn't know them when I went to jail, and they hung me out to dry, and I thought I could pay an attorney to get me off, and, that didn't happen. And so we need to know these things, just dealing with the American justice system,
That's right. That's why I love your opinion on this stuff, because you're going to give, like I said, a person like me, and, that's layman to a lot of this, we go off of emotions. Like, what is this judge doing? But really, in fact, when I researched it, a lot of the attorneys said the same thing what you said. And the judge was within his rights. It was kind of unethical for Georgia law because he was supposed to give those attorneys notification. And from 8:30 to 11 o'clock, he never notified anybody what was going on. And he could have just told them that we're in an ex parte meeting and left it at that. And I'll release, because he had the recorder in there, the stenographer in there, and I'll release the transcripts to you guys, and you can decipher, what is what. Active Chuck said, Thug's lawyer appears to be taking a stand against the court for hiding the fact that the witness is not cooperating from the defense. He believes that he was entitled to know that information. See, that was a whole nother thing too, because like I told you on Friday, this witness took the fifth.
Yeah.
And so for him to come back and start, and this part too, Adrian, the judge didn't come back in court and just tell them that they was in an ex parte. He allowed the witness to get back on the stand and start testifying. And then still had to come up and introduce this motion. So it's not like he came back and before we called the jury in, I just want you guys to know that he didn't do any of that. And so I think that's another thing that the defense attorneys was looking at him sideways about, because even though you didn't have to probably do it, this looked kind of suspicious, Judge. This man, we done got word he was in a meeting with you. You're not telling us it's an ex parte meeting. He was taking a fifth on Friday. Now, after this long meeting with you this morning, he's testifying to the prosecution. And so I could see why the defense took it, how they took it. Active Chuck, Nene says so true. Active Chuck said, who leaked the information to the lawyer is irrelevant. If the court and prosecutors are withholding information about the case, Thug lawyer is preserving the record at worst for an appeal. Well, I think that's why he made the motion, is to make sure he put it on record for an appeal. But in this case, Deuce M's, as Adrian was explaining and other attorneys explained too that I was researching, the court is saying that we need to address this first and then we can address your motion. Basically as if how Adrian described it. If you have an appeal or some paperwork to submit and you have a deadline from the court, you might have a legitimate motion, you might have a legitimate issue to bring up, and that can get you back in court. But if you miss that deadline, the court don't even want to address the motion or whatever issue you have. They need you to address, why was this deadline missed? And so I guess that's how the judge is looking at it. Like, before I even address that, I need to know, how did you get this information so I can know if this information is even credible? So it's like, I guess, introducing evidence in court. It needs to know where this evidence came from, who collected it, before this evidence can be presented to a jury to know if this is good evidence that could be presented to the jury. And so I guess that's the direction that the court was going in. We need to take care of this part first. Let me know, because it's gonna come out in the hearing anyway, who told, because everybody has to get on the stand. Now, here's the flip side, another side to this, Adrian, that I want your opinion on about this. So when the attorneys came in for Brian Steele, she said something that was very important to this. That judge actually would have to be recused from this hearing, because he is a witness in the case now. He is a witness in this hearing because he was in court. I mean, he was in the chambers. So she was just basically saying, when it's an ex parte, the judge, it wouldn't be an ex parte if the judge wasn't there. So by this attorney bringing up this motion, you are now a witness in this in this hearing?
Yeah, that's like super thin. That's super thin, right? You know, because when a judge is, is compelled to recuse him or herself from a case, there has to be, some integral parts, right? That creates a conflict. So that it was
Well,
thin
not recused from the case, Adrian. Recused
from
from
that hearing, from that motion, right?
right.
So no, that's like I said, it's paper thin. It's a thing in the law where they call it a harmless error, right?
Right.
So even if it was an error on a judge for saying criminal contempt versus civil contempt, it's still harmless. The man is still in contempt. That's how the appellate courts or the higher courts would come down with something like that. Because the judge put him in contempt, and it was a legitimate contempt issue, right? So same thing with the judge ruling about the ex parte motion and him putting still in contempt. I asked him for this information. He is a ward of the court. And I don't know the exact terminology that goes with that, but any attorney, whether it's a prosecuting attorney, whether it's a defense attorney, they're obligated to the court by law.
They are.
They are wards of the court in so many, so to speak.
Let me ask you this, Adrian. Here's another issue with it, because this is a lot. But what if Young Thug is the person that gave him that information? What if somebody told Young Thug and he told Brian Steele? Because Brian Steele did say it's attorney-client privilege, Your Honor. I can't tell you, but it would have to come out in the hearing. So if he was to tell the court then, he could be brought up on bar charges, correct?
Yeah, if the information he received is from his client, then
that's what he was trying to tell him.
Yeah, he can have a conflict of interest, right? So that is because you're right. When I think about it, that information could actually have came from Young Thug. More likely, whoever the witness is, because these witnesses, you see what's going on in the courtroom.
Exactly.
Dudes is bringing, Percocets and weed, and they still, they hood. You know what I'm saying? This is the life. So they getting cracking up in there. So for a witness, because even in my proceedings, witnesses they're incarcerated. You run into them. They try to keep you away as much as possible, but in a lot of instances, so more likely that is actually I kind of just you bringing that up. I think that's where the information came from, is from the actual witness, and the witness may have told Young Thug, and now the attorney can't break that confidentiality that he has with his client. But it creates a conflict only for that attorney, because now you're in contempt. You done brought this information up, knowing that you have to reveal your sources.
And that's what the judge said.
If you are a lawyer, you have to reveal your sources to the judge. And if you don't reveal your sources, you're in contempt of the court. And that, I recall a case where a reporter, stayed in jail for months. And I forget the case has been, that was years ago, maybe about 4 or 5 years ago.
Oh, he'll be in there for months too, Adrian. He got to go for 10 weekends and turn himself in.
Yeah. So by him knowing this information, possibly, because I think you're right. I think it did come from Young Thug now. Because the judge began, you remember the judge named off everybody who was privy to the ex parte motion.
Right.
And and he had confidence in his bailiff. He had confidence in his the stenographer. He had confidence in the prosecuting attorney, the district attorney, assistant district attorney. So more like, and it didn't come from the judge himself. So yeah, it may have come from the witness, but by the this defense attorney bringing in this information, knowing that it came from his attorney, I mean from his client, you know, he's preserving all these arguments for appeal, and
Yeah.
that's what he's doing. He's preserving all these arguments for appeal. So you know, but it's a slippery slope that he's on.
So he took one for the team basically, because his back is up against a rock and a hard place, and when your back is up against a rock and a hard place, you got to find the softest place to fall.
Yeah.
And the softest place for him was to take the contempt versus go to the bar and lose your license, possibly for telling something that your client has told you. And I think that's what he basically told the judge, but the judge don't care. The judge want to know who told.
Because the judge can't make an assumption that he got it from his client.
Right.
Only thing the judge knows is that you have information that was only privy in this ex parte hearing.
Yeah.
You know, so that's the only thing the judge throw out an accusation. But like I say, when it's baseless and you have no evidence or anything to back it up, you know, you can try to do things, you know, in front of the juror, because the juror, they're human beings. But when it comes to the law, like I say, it's unfeeling, it's unemotional.
Well, it's a tough pill to swallow. The ending of it is that the judge, after going in the chambers for like 2 hours, he came back. He told Attorney Steele he's still in contempt of court, criminal contempt of court. He didn't give him a bail. He said that he will be doing 10 weekends in the county jail until August something. And Attorney Steele asked him, can he be in the same cell as his client, Young Thug? And he told him that he's going to try to make that happen for him. So he said, so he can work on his case, because the other issue with this is that when you arrest a client's attorney during trial, and that defendant wants that attorney, because that's his right.
Yeah.
For that trial, then you take a chance of getting that trial put off, because you would take the defendant's right away from him for having his attorney.
Yeah, it can possibly, like, you know, they can delay the trial. They can declare, you know, a mistrial, which is, you know, they're not going to do it. That's rare. But, you know, you can just put it off for a later date until the defendant finds suitable representation, you know.
Shadow on TikTok say, hey, Fulton County is out of control. They just making up new rules. Well, they do have a lot going on. I mean,
there's so much going on. I didn't know we were going to stay on this topic of the contempt topic, because it was so many other things that's going on with this case that, you know, needs to be out there, that the people need to understand and know.
We're gonna get back on it. We're gonna get back on it. But I wanted to address what was going on. I know a lot of our viewers, they wanted to know what was going on with this the attorney, because no one has really ever seen anything like this, with the attorney getting arrested, and then he's going to be spending weekends in the same cell with Young Thug. That was kind of like, put me in there with my boy. Don't put me nowhere else. I need to be protected. But so yeah, that was a good thing. I guess that was a good thing, because who wouldn't want to be in the cell with their attorney when they go on the trial? Like,
yeah. You know, I mean, boy, but you know, you got these attorneys, man. It's like you said, boy. It's a 3-ring circus. You know, it's a shit show, man.
Oh my God,
going on in that trial, man. But you know, I mean, for a defendant, you know, other than sitting on his pocket, sitting in jail, you got to love it, you know, because it's so many different things coming in that it throws the jury off so much that it's rare. I don't see them getting a conviction, you know, a 12 jury conviction, 12 people agreeing. I don't see that, you know, because there's so many different moving parts. And
too many moving parts. No one can keep up with this mess. And
Yeah,
they,
I'm still here. Let me grab this.
huh?
No,
They've,
I'm still here. Let me just put this up.
no, that's okay. They've still yet, in my opinion, I still haven't heard anyone tying Young Thug to anything that's like on the statutes of murder or something like that. So it's going to be interesting to see what the jury. We are going to unpack some more of this stuff because it's our followers want us to.
Yeah.
And we got to give them what they want. We got to give them what they want. We're going to give y'all what y'all want. Right. And so Nene say, I like that. We had Sticky pull up on us. I want to thank all of our chat liners for coming in to support our show. Hootie Who's Finest is in full effect. We got some more content coming, but I want us to as good stuff come along. I know there's some stuff in this that you want to get out there. So I want to unpack that because we have a lot of young followers, and it's important that we educate them on this kind of stuff because they don't know. And just like you explained some stuff to me that I didn't know, and I was researching some stuff and I was like, wow, I didn't even know that. And so that's why it's a good thing to talk about these court cases. That's why I love talking about these court cases. But I want to thank you, Adrian. How's everything been going for you? We got about 5 minutes before we close.
5 minutes? Wait, hold on. What? We're not getting to the letter? Oh, okay. What time is it? Oh, I see we got like 10 minutes left, right?
Yeah, because we're gonna have to take a day for your letters, Adrian. We need to do an extra day when you're not busy, when we're not busy for the letters. What you think about that?
Yeah, we can do that. Several of the letters that we received that I do want to get into. And I'm suspecting that they're waiting kind of like, for a response. So yeah, I do want to get into it, but outside of that,
so what's going to be a good day for you to do it? What about, what you think about tomorrow?
Tomorrow, no. If anything, it would have to be next week. So tomorrow, Friday, Saturday, Sunday, just kind of like, I got a heavy schedule.
How about you read? Messy Mar said, "How about you read the letters first thing when the room starts?" Well, the reason why we used to do sort of that, but the viewers really, we lose the viewers when that happened. The viewers is tuning in for the current event content up front.
We're gonna give it to them.
So that's why I think we need to do like a separate show for the letters, because when we get into the letters, we be into the letters. The letters take a good 30 minutes from us going back and forth, giving people our honest opinions of what's
we got some heavy letters. I'm talking about big things. Woo!
We need some time, but we do need to keep our viewers with the current event content as well. So we definitely have to probably schedule another day. We just got to see when you're not busy, and I can work around that schedule for another day for the letters. Even if we do a extra day, maybe every other week. It doesn't have to be every week. But
we'll get into it. We'll definitely address those letters. So for those people out there, man, we're on it. We're on top of it.
And we're gonna address them next week. Even if we address some current event stuff, I'm gonna make it where 30 minutes left before at least one of the letters, because we have one that we definitely need to address immediately. Nene said, I'm ready. She ready for whatever, Adrian. She ready for it. Nene ready for it, Adrian.
That's what I'm talking about.
Definitely need its own day for the letters then. Yeah, because it's people personal stuff, and then I don't like rushing the letters. I like spending time on them because it's people personal stuff. This stuff
Yeah.
is people personal stuff, but it's current events.
Yeah, I get that. You're absolutely right. And, you know, but some of the contents in the letter, you know, it's like some universal things that everybody we deal with on an everyday basis. So being able to talk about it and get some opinions from the viewers, you know, we're like, you know, we're creating like, you know, coping strategies and, you know, ways to you know, kind of deal with these negative things in a positive way, you know?
Right.
Yeah.
And that's why it's so important. So we definitely, you're gonna give me a day tomorrow. You're gonna give me an extra day, Adrian.
We're gonna next week.
Monday. Yeah, I mean next week. It could be Monday.
Next week for sure. I'll talk to you offline, and we're going to schedule a day to address the letters. There's 3 of them that I definitely want to get to. So,
Okay.
Yeah.
Perfect. All right, y'all. Y'all heard it from the horse's mouth. I don't want to call him a horse, but y'all heard it from Adrian's mouth.
Words.
Give us a day so we can address those letters because
and y'all got to come back through. Like, subscribe, all the stuff.
Those letters are good, and like Adrian said, it touches all of our lives. It's everybody that went through
form of fashion.
What's in those letters, but those people that wrote them are going through them right now, and they need some answers right now. Nene say, I love y'all. We love you too, Mama. We will see you next week. Make sure you pull up. Same place, same time. Hootie Hoo's Finest Talk Show. Adrian, give him a big hootie hoo this time.
Hootie hoo! You know, it don't take too much for me to get active. I go, man. You know? Yeah.
Until next time, Adrian, we are out.
Peace.
Peace.